Regulation is an essential part of running a well-functioning economy and society, but must be carefully designed so as not to have unintended or distortionary effects, such as imposing unnecessarily onerous costs on those affected by the regulations or restricting competition. Assessing the impact of regulation, including analysing the costs and benefits, is therefore important to ensure that it delivers the intended objective without unduly causing adverse effects. If regulatory options are being considered, such as self-regulation, where governments expect business to comply, quasi-regulation, co-regulation, and black-letter law, then COA councils must subject these options to a regulatory impact assessment process through the preparation of a draft and final RIS. The purpose of a draft RIS for consultation is to canvass the regulatory options under consideration in order to determine the relative costs and benefits of these options. The purpose of a final RIS for decision makers is to draw conclusions on whether regulation is necessary, and if so, on what the most efficient and effective regulatory approach might be, taking into account the outcomes of the consultation process. The basic feature of a RIS is the systematic examination of the advantages and disadvantages of possible methods of achieving the objective. A number of quantitative approaches exist to assist in evaluating options as part of the regulatory impact assessment, including risk analysis, cost-benefit analysis, measuring business compliance costs, and assessing effects on competition. Detailed advice for COA councils on these quantitative approaches, risk analysis, measurement of business compliance costs, and assessment of competition effects, is included in the GOAG Best Practice Regulation Guide. The OBPR can also provide advice and assistance and is responsible for monitoring compliance with requirements set out in this guide. The following steps for preparing RIS are provided to assist COA councils, including their secretariats or advisory committees, in determining appropriate courses of action and maximising the effectiveness and efficiency of new regulation, taking into account the principles outlined above. As a general rule, the level of detail within the assessment should be commensurate with the impact of the proposed regulatory measures.